Okay, this is part 9 of this fiasco of a Chabad trustee in Berkeley. He became the trustee of a cancer patient's trust, but he didn't give the man's siblings anything. Nothing. Case number RP22120163. This is a story presented by Nightline NBC. You got a special exclusive here on YouTube. Preview. The court declared the user a vexatious litigant based on these trumped up. Apparently, what the opposing side did was they said, hey, make him a vexatious litigant because he's fighting for his inheritance without an attorney, because he couldn't find any that would take the case because it's less than $2 million. So they said, here's a list of 30 lawsuits the guy filed. Make him a vexatious litigant. But it was only 5 different lawsuits. They just reprinted them 30 times. The guy objected, but the judge didn't care. So now he's labeled as a vexatious litigant, and that makes it impossible to fight a case. So if they're not trying to silence him with the restraining order against his First Amendment rights, then they're trying to shut him down in the courts. The court declared the user a vexatious litigant, opposing a pre-filing order. This pre-filing order means that the user cannot file any new case in California without first obtaining special permission from a judge. Okay, hold on here. So because we're wasting time here, because almost no attorney will represent someone labeled a vexatious litigant, and because trust litigation attorneys rarely take cases under very high estate values, this designation has effectively blocked the user from assessing the courts, prevented any new petition from enforcing the trust, and placed them in a legal trap created by false statements submitted under oath. The user apparently has 2 active appeals in the Court of Appeals. These appeals challenge the probate court's adverse rulings and the vexatious litigant designation. In this appeal, the user argues that the probate court erred by granting a motion for judgment on the pleadings despite unresolved factual issues and failing to address the trustee's alleged concealment of the original trust, which prevented a timely contest under California law. Trust contest deadline may be told or excused when the trustee withholds or conceals material trust documents, preventing the beneficiary from discovering grounds to contest. The user argues that the original 2019 trust was never disclosed within the statutory 120-day period. The probate court should have allowed the trust contest to be heard on its merits. In one appeal, the user challenges the pre-filing order on the grounds that we got 10 seconds to go. The designation was based on false declarations. The court duplicated and inflated case counts. The user